Mora.
I am the president of the Law Society. Mr. President, I want you to read for me. I'm Chilean. You should drink food.
What is it?
I give you a cup. The mask.
Morning.
To greet you. See you, man. It's starting to greet you. Where's your this? Anika Kora Mapo, we need to introduce you. So the AG is the titular of set up your team.
Yes. What in that?
Mora. Taka libida kidogo.
President Nelson Harvey, President Eric Perry, yes, President Eric Perry, Senior Harold Ndubi,
Ilikuwa yako.
Rebecca Omwenga, Joshua Nyawa, for the first, third, and fourth respondents. That is the forum.
So today we are here to issue summons last week. We are aware that this petition involves disappearance of 3 people who are allegedly abducted, and there has been no response so far from the respondent side in terms of giving us an answer to what the petition seeks. So I'd like to find out from the respondent whether those summons have been paid or not.
When you made the order for the appearance by the first respondent,
this morning at 10 a.m. On the date, my Lord, we did indicate to the court that the acting Inspector General of Police was held up at the coast, specifically Lamu, and that he was proceeding to the north, the northeastern corridor of the Republic. That is Wajir, Mandera, and those sites. My Lord, we did indicate to the court that the operational matters that the IG is involved in are in the context of securing the Republic, and that while we do not disclose in public the nitty-gritties of those operations, it is in the public domain. The character and insecurity that the country has been facing from the side of Lamu and the side of Pakistan.
We just need to give indications of compliance with your order. Whether we have the first respondent here, so that those details have to be given by the first respondent or the first respondent's representative for that matter.
My Lord, I'm laying a basis.
Let him just...
Explanations are given to the court. We have the DIG in charge of the Kenya Police Service for the court. We plead with the court, as Andrew, pray that the court grants him an opportunity to explain the order that this court issued and if I may just read the order, my Lord. It was for the appearance for an explanation why the habeas corpus orders have not been complied with. Lastly, my Lord, as I finish, and I wanted to go on record, because we have said it time and again, that we had filed an affidavit.
It was the reason why they did not look at that affidavit is because the issues were referring to came much later, even after the court had issued those orders and made a rule for the attendance of the police.
Thank you, my Lord. At least the affidavit is being acknowledged.
Yes, we will look at that.
Thank you, my Lord. So I will plead that.
And so as it is, the orders that you issued on the 26th of August to date the first respondent is still in contempt. My Lord, on 3rd of September, when we came back before this honorable court, and even when granted a second chance at 3 p.m., he did not attend court. And my lord, it is in the public domain that the first respondent was taking pictures and having a tete-a-tete with the Cabinet Secretary Interior, the DCI Director, and the Deputy of the National Police Service, and the same were posted and shared by the Cabinet Secretary of Interior on his X account. My lord, similarly on 5th September 2024, they were given another chance to attend at 10 a.m. There was no appearance. At 3 p.m.
If government cannot protect its people, and they come here shamelessly telling which language? Yes, sir. No. I am addressing you.
Yes, but
and also addressing my government.
okay, you have said about the government, I've recorded that.
Yes, all I am saying is
Not recorded
that
the
a government must protect its people.
Yeah, that is important.
It is important that they explain what we have done, and we are unable to get these people where they are, or we arrested them and they are in such a place. It is not feasible that they should come to court and say, oh, sorry, our IG is in Garissa. What is that? They should be filing an affidavit to tell you what they have done to look for these people, and they are either able to find them or unable to find them. And lastly, all of us are equal before the law. Whether you are an IG or a deputy IG, like Mr. Lanat, whom I have not met before, but I can see his badge. We need to obey court orders. Court orders must be obeyed at all times. And with your permission, I need to go to some chemist to get some medicine. I therefore seek your indulgence that I may walk out.
They refused to stand up and submit their position. As I indicated, my lord, I'll be very brief. My work here is to give context as to the contempt instances from the time this matter was filed. On 26th of September, my lord, we served this court order to summon the Inspector General, the first respondent in this matter. My lord, they did not appear. The second instance of contempt is on 3rd of September. And my lord, you issued orders at 10 a.m. There was no appearance. You issued further orders at 3 p.m. There was no appearance. My lord, those are 3 instances. My lord, on 5th of September equally, you issued orders that he appears on 5th of September at 10 a.m. He did not appear. A 5th instance of contempt of court. You were gracious enough to direct that he appears at 3 p.m. My lord, he did not appear. Cumulatively, these are 6. Today morning, it's the 6th instance that the Inspector General produced, the first respondent, has refused to comply with these court orders. My Lord, that is the context within which we find ourselves as petitioners in this matter. Will this court give another chance for the Inspector General to appear before it? My Lord, if that is given, then it will be a further violation of the Constitution, particularly Article 10 of the Constitution. The Inspector General has a duty, which duty is abrogated. Your directions were that he himself, not his deputy, appear before you. Having given that context, my Lord, I want to invite President Nelson Harvey to make his submission.
That I will stand here today, having stood in this very court about 5 years ago before your brother Justice Luka Kimaru on a matter similar to this. Having appeared before this court again 7 years before your very same brother Justice Luka Kimaru on a similar matter. I'm talking about the matter of Miguna and the matter of Willie Kimani. My Lord, the conduct of the first respondent must be deprecated by the court. And in the strongest terms possible. My Lord, the very criminal justice system that the first respondent stands for is incapable of performance but for reliance upon court orders. It will therefore be turning logic over its head to allow the National Police Service, which comes to this court day after day for summons, to compel attendance, for warrants to enable a search, to fail and attend court to give an explanation as to the whereabouts of 3 Kenyans. Lord, and it's for that reason that at the tail end of this discourse, we will ask the court to do 2 fundamental things. 1, to convict the holder of the office of Inspector General of National Police for contempt of court. And 2, to sentence the holder of that office to the highest permissible penal consequence. And if 6 months is the highest permissible penal consequence, it must be cumulative for the 5 orders hitherto disobeyed.
Said before you, my Lord, I've had the privilege of appearing in several of these cases. The first case we appeared in was the case of Willie Kimani. My Lord, I've always believed to date that it is the actions that the Law Society and other players took to move to court for an habeas application. Willie Kimani, the disappearance of Willie Kimani. And my Lord, it is the action that was taken And my lord, even in that case, orders were issued to the Director of Criminal Investigations and to the IG. And it is those actions that were issued then that were critical in the subsequent conviction these proceedings are. And my lord, we issued 2 orders. One for the attendance of the first respondent, and second one for the release of the second, third, and fourth petitions. My lord, both orders have not been complied. My lord, the other case that I have been involved in was an advocate who was at court. The court issued similar orders. He was released, but his client was never released. And my lord, up to date, Professor Nandwa knows and acknowledges that he owes his life to the orders that were given by this honorable court. And to date, he has never opened up at exactly what happened when they picked him with his client. In fact, if you want to make him cry, just ask him what happened. The third instance, my lord, is of a client of mine who he appeared in court. He had been taken by police at Saret Center. And the court also issued similar orders, summoning the IG to appear in court. Subsequent to that, he was released. He's been brave enough to tell me exactly what happened. But my lord, the wife tells me that for him to sleep at night with the lights off is a big problem. And so, my lord, I wanted to say this to underscore just how important the orders that you give are.
4 marks an important turning point for the rule of law in this country. The court summoned the Inspector General of Police to physically appear in this court at 10 a.m. to clarify or explain why summons issued to him in respect of the second to the fourth petitioners have not been complied with. The summons were issued on the 26th of August 2024, requiring the acting IG to appear in court on the 9th of September 2024 over alleged abduction of 3 persons, second to the fourth petitioners, whose whereabouts are unknown since the 19th of August 2024, in what the petition describes to be actions by agents of the first respondent. The acting Inspector General of Police, that is the first respondent, has not availed himself as directed and has instead sent his representative, the Deputy Inspector General of Police, to appear on his behalf. On the 5th of September 2024, Ms. Mwangi for the Inspector General of Police pleaded with the court stating as follows. The Inspector General of Police has not said he is not coming. He is requesting for another date because it is our position that the second, fourth respondents are not with the police. The Inspector General is requesting another date to appear because we are without his officers who would explain. The ID is requesting another date to appear in court after, and then in brackets, after holding brief consultation, Ms. Mwangi said the IG will come on the Monday, 9th of September 2024. The officers of the IG, the officers of the IG are here and have confirmed his availability on Monday considering his work and duties. End of quote. in spite of the very stiff opposition from the petitioner's side, the court, after the Inspector General skipped the attendance at 3 p.m., which the court reluctantly extended on the 5th of September 2024, extended the matter to the 9th of September 2024, estimatingly noting as follows. The stream of reasons and excuses by the Inspector General of Police are definitely bound to run out. To proceed at this juncture, though an extra make a finding of contempt of court may be seen as premature in a grave matter of contempt of court, which is a form of criminal sanction, as an offense against administration of justice. Our Constitution requires a high threshold for criminal matters. Reluctantly, the reasons for non-attendance today must thus be considered. It is thus necessary that I postpone these proceedings to Monday, the 9th of September 2024. The Inspector General, having already indicated his availability on this particular day, should have no further excuse but to comply and attend court physically at 10 a.m. so that this court can put this matter to an end. In spite of what transpired on 5th of September 2024, as indicated above, we are here on the same spot today. As of 5th of September 2024, it is evident that the court had directed the Inspector General to attend the court and was clear to the respondents that delegation had been declined by the court. We are now back to the same stream of excuses that the court had clearly listed for snubbing the summons by the head of the police, who should be explaining to the court whether or not the Kenyans in question are in the hands of the police, or if not, what has been done to avoid or to get to the bottom of the matter. The court appreciates that the Inspector General of Police can delegate, and that is possible in law. It also appreciates the fact that the Deputy Inspector General of Police is a high-ranking position, and the DIG can actually the position of Deputy Inspector General of Police is a high-ranking position in the police service. However, the matter at hand may not practically be dealt with by way of a delegation, considering that summons have since mutated to what the court considers to be contemptuous conduct. What simply the Inspector General has done is displaying an attitude that he is either too busy to be bothered by the court orders, or even when there are matters relating to life and safety of Kenyans, which he is required to protect. A failure to appear in court pursuant to a duly issued summons amounts to a direct contempt, particularly where the opportunity to appear has been extended and ignored. This is willful disobedience that undermines not only the authority of the court, but the supremacy of the law and administration of justice generally. Such an attitude affects the rule of law and makes the citizens vulnerable, knowing that the law cannot protect them. It may be the same feeling that the petitioners in this petition now feel, considering the conduct of the first respondent so far. The Constitution of this country has given this court the mandate to uphold and enforce it on behalf of Kenyans. The Inspector General of Police is a state officer established under Article 245(1) of the Constitution. He is appointed under Article 245(2) and bestowed with a mandate to exercise independent command of the National Police Service and to pertain to any functions prescribed by the national legislation. Article 74 of the Constitution provides that prior to assuming state office, state officers must take oath of office. It provides as follows. Before assuming state office, acting in state office, or performing any functions in a state office, a person shall take and subscribe to the oath of affirmation of office in the manner prescribed in the land schedule or under an act of parliament. The oath taken by state officers, such as the first respondent, have one common denominator. They swear allegiance to the Constitution. This shows that the exultant place the Constitution occupies as a reassurance to the public that state or public officers entrusted with public power will always be guided by the constitutional values and principles. That they will rule, that they will respect the rule of law, human rights, be accountable, and act professionally, among others. It will require them to abide by the orders of the court as a guardian of the Constitution and constitutional order. Yet, it has now become commonplace that individuals who take and subscribe to this oath of office and assume public offices have resolved not to abide by court orders and are treating the court orders with outright abandonment. The Bill of Rights that is supposed to safeguard the rights of Kenyans is no longer matters to some. It is the responsibility of the court to restore accountability to the people of Kenya by holding the persons, however mighty, accountable. It may come at a considerable cost, but this must be done. The court has a responsibility to punish deliberate actions that undermine the Constitution and its authority. The faith and the trust of Kenyans in the rule of law that they have suffered for too long cannot be taken for granted and decimated through acts of impunity. The Constitution, at Article 247, sub-Article 7A, does in fact acknowledge the Inspector General can even be removed for violation of the Constitution, subject to following the red-down process. It provides that the Inspector General may be removed from office where there is serious violation of the Constitution or any other law. And a deliberate refusal to abide by the constitutional order or summons undermines the principle of rule of law under Article 10(2)b, and the failure to attend court to explain circumstances surrounding the disappearance of 3 petitioners undermines the principle of accountability by a public officer and institution. Ends of institutions must now be held accountable for ensuring constitutional values and principles are adherent to, particularly on a matter of human rights and the rule of law. As held this court at ransom, the court is no longer able to ascertain the truth of what might have happened to the petitioners. It was held by the Court of Appeal in the case of Dr. Fred Matiang'i and another versus Miguna and 3 others that bold impunity, open defiance, or cynical disregard of the authority of the court and the integrity of the judicial system cannot be countenanced, and those hell-bent on it will find neither help nor refuge, and self-serving appeal to natural justice where their imprudent conduct threatens the very foundation of the rule of law. It is my finding that the first respondent, Acting Inspector General of Police, is guilty of contempt of court, and the court ought to punish him accordingly. Further, the court would like to note that there has been unbecoming conduct by a senior police officer, the former JPU Commandant Lazarus Opicho, now the head of VVIP Protection Unit in the police, which the court considers as bordering on intimidation. Now, thus order that Mr. Lazarus Opicho be and is hereby summoned to explain the conduct that included calling my bodyguard and the driver, trying to ascertain my whereabouts behind my back. I also need to ascertain what the reasons behind such an inquiry and many other concerns. I thus reserve the sentencing together with the explanation by Lazarus Opicho to Friday, 13th of September 2024. Having found the first respondent, Acting AIG, Acting Inspector General of Police, guilty of contempt, the court is now free and ready to take the explanation provided by the DIG, since there is no more impediment to the hearing of the matter, the finding of contempt having been made, after an opportunity to punish the contempt having been extended and not taken. The court has no reason now to decline to hear the DIG, who is before the court, so that this matter can be put to rest.